We'll hear from Aziz Huq, who's the Frank and Bernice J. Greenberg Professor of Law at the University of Chicago, where he focuses his teaching and scholarship on common law, criminal procedure, federal courts, and legislation.
Thank you. I'm going to use my remarks to say a little bit about where things stand with respect to immigration. And the question that I want to take up is what constrains immigration reform in a way that, in a direction that is consistent with our values and our Constitution. Is it the Constitution itself? Is it the courts? Or is it laws? And I want to suggest that laws, and in particular statutes that Congress passes, are central to the forms or the pressures that are being imposed upon immigration and immigration enforcement right now. And I think we see this in three different fora, three different controversies that are unfolding in the immigration context, two of which Representative Schakowsky mentioned. And what I want to do is to step through these three controversies and explain why the law matters, and in particular why the law matters, why statutes matter perhaps more than the Constitution. The first of these controversies is the debate over sanctuary cities. In an executive order dated January 25th, the President directed that a class of jurisdictions that he labeled sanctuary cities would be denied all federal funds, and if they declined to cooperate with new national law enforcement priorities. The city of San Francisco and the county of Santa Clara took the President to court in relation to that executive order. And Representative Schakowsky mentioned the district court's decision issued by Judge Orrick of the Northern District of California, staying and joining the application of the January 25th executive order nationwide. Now, the core of that judicial decision is a set of constitutional rules. Judge Orrick finds that the executive order exceeds the President's authority under the available statutes that allow for spending to localities and states to be conditioned. He finds that the order would be an impermissible form of commandeering, and he identifies federalism problems with the order. But and so one takeaway one might have from Judge Orrick's decision is that here's an example of the Constitution checking the President. But if one scrapes back a little bit from the surface, down from the surface of Judge Orrick's opinion, one sees that by and large his constitutional holdings depend upon the substance of federal statutes. Principally, there are federal statutes that condition the availability of federal funds to states and municipalities on compliance with certain conditions. And depending upon how those statutes are written, depending upon how different statutes, appropriation statutes are bundled together, the President has more or less authority with respect to the availability of funding as a point of leverage with respect to states and municipalities. And so it is really a function of the precise calibration of statutory conditions on federal fundings to cities like Chicago, to cities like San Francisco, that determines the scope of presidential authority. And there's no reason to think that that scope of authority is going to remain unchanged. Right? And while it is true that there are certain things that the Constitution prohibits even Congress from doing with respect to federal funds, those constraints are at least hazy as a doctrinal matter, and it's not clear that they would constrain necessarily the President from pursuing the same immigration-related enforcement ends that he's already said that he's going to pursue. We see the same dynamic in the travel ban litigation. So again, as Representative Schakowsky mentioned, the Fourth Circuit, sitting in Bonn, recently invalidated Section 2C of the March 6th executive order that imposed a ban on 6 countries' nationals from entering for a 90-day period. The majority ruling in the Fourth Circuit by Chief Judge Gregory is based upon a finding that the executive order pursues an improper purpose. It pursues a purpose of discriminating against a discrete group on the basis of their religious identity. The thing to notice about the Establishment Clause holding is how easy it would be for a halfway competent administration to circumvent. It is just not that hard to run an interagency process that results in an immigration order that targets certain groups or certain nationalities in ways that has predictable disparate impact on certain religious groups. That the White House was palpably unable to run such a process, and indeed initiated a process that resulted in the Department of Homeland Security's own intelligence analysis unit leaking its own analysis that showed the absence of evidence, is a testament to managerial incompetence. It's not a testament to the limits of presidential authority. More telling is the fact that there is a concurring opinion to the Fourth Circuit's majority ruling. A concurring opinion by Judge Barbara Keenan-Milano that I think warrants a lot more attention than it's received in the press. What Judge Milano points out is that the statute that the President purports to act under requires a finding that those persons, those aliens or group of aliens who are subject to a bar under the order, in fact represent a danger to national security. The order that the President released makes no such finding. It contains a set of boilerplate with respect to the nations that these the aliens are from which aliens are banned, but says nothing about the actual people who are banned under the order. Indeed, the order says that the justification for a temporary ban is administrative. It's to allow an interagency process of review to occur. Right? By the way, the 90 days that would be required for that interagency process have now elapsed. One queries whether the fact of that elapsing will make any difference to the administration's demand for the order. Judge Milano's holding, I think, or Judge Milano's identification of the limits that the statute imposes, I think is far more durable than the finding of impermissible intent that the majority's ruling holds on. But Judge Milano's ruling rests upon a federal statute. It does not rest upon the Constitution. One final thought. At the periphery of our vision as a nation is the fact that the way in which immigration enforcement is happening on the ground is dramatically changing. The number of individuals being arrested by ICE in the country has gone dramatically up. The level of fear that non-citizens who are undocumented feel because of the elimination of enforcement priorities on the part of ICE has dramatically spiked. The way in which people are treated at the border, whether or not they are citizens, depending upon their perceived ethnicity and religion, depending upon whether they're carrying a device that the CBP agents would like to examine, has changed dramatically. Right? The number of device searches, for example, has increased by an order of magnitude from this time last year. The number of visas given to people from Muslim-majority countries is down 20% from this time last year. All of those dispersed changes in the manner of enforcement are exceedingly hard to get at through litigation that focuses upon intent or focuses upon constitutionality. The constitutional rules, in particular with respect to the uncovering of illicit intent, are extremely weak. Rather, the levers and the instruments that can be used to address those diffuse problems lie, I think, in the first instance with Congress. Right? And Congress's ability to restrict and to channel the manners of immigration enforcement that we see on the ground. So I would suggest that even though we have seen in the courts what I would view as normative victories for constitutionalism and the rule of law, don't expect that those victories can rest solely upon the Constitution if they're going to be durable. The law, the statutes, the regulations matter a great deal. And one needs to pay attention to what's going on at the sub-constitutional level, therefore, not just the big-ticket establishment clause or First Amendment.